Major breaking news out of California. A federal district court judge has declared that California's one gun a month purchase rules, that says you cannot buy more than one gun a month out there, is unconstitutional under the Second Amendment because the state of California could not come forth with a single representative, well-established historical analog ever in American history to warrant such an intrusion on the right to keep and bear arms. Major victory out there in California. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Down, a proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many books, including Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. Wait till you see the next one coming out very soon. We'll talk about that soon. All right, folks, so major decision, federal district court judge in the case of Guyon versus Bonta involving the Firearms Policy Coalition and the Second Amendment Foundation. Big win just came out. The district court has granted summary judgment in favor of the Second Amendment plaintiffs against the state of California. And in doing so, it issued a 24-page opinion that held that California's law limited people to one gun purchase per month is unconstitutional under the Second Amendment and under the Supreme Court's precedent on NYSERPA versus Bruin. Again, this case involved California's law that prohibited the purchase of more than one handgun or one semi-automatic centerfire rifle within a 30-day period. There were, of course, special exceptions for Hollywood, the film industry, and a special exception for law enforcement, the people that surround Gavin Newsom. Those people are exempted from this, but you ordinary peons in California, you ordinary American citizens, you are not. The good news, though, is that this federal district court judge, I'll put an opinion down below, issued a major decision saying this is absurd, this clearly violates the Second Amendment. To begin with, the way the court went about it, very nice opinion here, nice and succinct, laid it out nice and smoothly, and basically says, look, take a look at the 2008 Supreme Court decision of Heller that says, there's language here that says, and again, it's Heller and Bruin, you start with the text of the Second Amendment. Well, the right of the people to keep and bear arms shall not be infringed. In order to keep or bear arms, guess what? You need to be able to acquire arms. And any kind of hindrance, remember, the right of the people to keep and bear arms shall not be infringed. We've talked about the definition of infringed, which means based on 18th century dictionaries of lexicographers like Samuel Johnson from England and Noah Webster from America. Guess what? To infringe means to hinder in any respect. It also means to destroy, but it means to hinder. So obviously, if you're preventing me from being able to acquire additional guns or guns, guess what? That is a hindrance on my right to keep and bear arms. So now the text is implicated by a modern day gun control law. And what happens? Well, the judge gets it exactly right. The burden shifts to the government. And now the government has the burden, a heavy burden, to come forth to show that the law that they're trying to defend, in this case, a one gun per month purchase regime, is somehow constitutional going back to the founding. And this federal district court says, no way, no how. Obviously, the plain text is implicated. You obviously are, the keep and bear arms is implicated. But now they say, what is the government have to do? And now the court basically turned to the government and says, you have to come forth with historical analog laws going back to the founding, that there was some restriction on the number of guns Americans could acquire each month or in any time period. And that simply doesn't exist. By the way, the court even bent over backwards to help the government to say, look, I'm going to give you the benefit of the doubt. I'm going to pretend that there are new societal issues in America today that somehow warrant making it easier for you, government, to come forth with historical analog law. Just to remind you, in the Bruin case, it basically says that if you're dealing with an arms ban case like in Heller, or some sort of licensing regime like in Bruin, those are really straightforward cases, and the laws that the government has to come forth with have to be distinctly similar. They have to be very, very close, and we've talked about that before. But if you're dealing with unprecedented societal issues or unprecedented technological changes, something sort of brand new, if you will, then it's possible the government still has to, by the way, the government still has to come forth with historical analog laws. It never gets out from that burden. But the historical analog laws the government has to come forward with can possibly be a little looser to justify the law than in those other cases dealing with arms ban cases or things involving licensing. So even under the looser, more nuanced standard, for the sake of argument, the court said, the government of California still has absolutely nothing to show. You know what they're going to trot out here, because we've talked about on this channel before. guess what California does? Well, first of all, they trot out their usual tried and never successful argument that there were founding era gunpowder laws that limited the amount of gunpowder you can have in a home, but the court quickly dismissed those. I'm sure, having watched several videos here at the Four Boxes Diner, quickly dismissed all those as absurdly and not analogous. Why? Because those are really fire safety rules. The reason why you cannot have massive amounts of gunpowder in your home is because black powder then and today is highly flammable. And when the entire city was made out of wood, like Boston, guess what? If any of that caught fire, you'd burn down the whole city, which the founding fathers were aware of that risk, because in the year of our Lord 1666, the whole city of London burned down in the Great Fire over there. So fire was a really big deal at the founding era. By the way, you could still have pounds of black powder in your home. You just could not have whole barrels of it, things like that. So there were restrictions. But again, the concern was don't burn down the city of Boston. It was not a crime control issue. It was not a gun control issue. So therefore, using fire code laws to justify a modern day gun control law like this one gun a month rule is simply not allowed, is simply a no-go. And that's what the federal judge said here. Moreover, the government of California came back and tried to rely on rules involving restrictions involving Native Americans, and that they could not have guns, you couldn't sell guns, things like this. And again, I'm happy to report that the judge basically chastised California, being like, look, these laws would be clearly unconstitutional today, and you can't rely on laws that would be unconstitutional today to justify a law involving the Second Amendment now. That also is a no-go. By the way, just as a side note, the other argument that California tried to raise and did raise and really argued was that there's this language in Heller in 2008 by the Supreme Court that talks about, quote, presumptively lawful laws. And one of those presumptively lawful laws involves conditions and qualifications on the commercial sale of arms. Now, this is basically saying, look, if it involves issues associated with just basic commerce, we're not going to strike those down. That's just like business law. But the court went on to say that does not allow, that has nothing to do with the one gun a month rule. I mean, presumably issues associated with the commerce of law, the commerce of buying and selling guns might be things like, well, if you have a law about like the number of square footage you can have in a store or things like that, that's really what we're talking about here. You have to post certain signs about consumer disclosure laws, or maybe you have to deal with, employee rules or wage laws. That's what they're really talking about, these kind of basic things that involve gun stores, but they're kind of ubiquitous and go outside of the case of, people involved in the gun business. Nevertheless, the court here said that there's simply just quoting that dicta of Heller saying that, laws involving the commerce in firearms are presumptively lawful is not enough, because the court went on to say that these types of laws did not exist until the 20th century. The Supreme Court has repeatedly said that laws that really start in the 20th century are not presumptively constitutional because they start way too late in American history. So again, the judge goes on to basically say, because these laws dealing with restrictions on the firearms industry come in the 20th century, it requires the court to do the full-blown historical analysis and look back to the time of the founding to see, are there historical laws that would somehow justify a one gun per month purchase rule, or something that can't have more than one gun a month in terms of how you buy them. And of course, the court said there's clearly nothing like that, to say the least. And as a consequence, what the court ordered was very powerful. He entered summary judgment in favor of the Second Amendment plaintiffs. Specifically, this is what the judge wrote. Conclusion: it is hereby ordered that defendant's motion for summary judgment is denied, and defendant's Daubert motion to preclude testimony of George Moskery is denied as moot. It is further ordered that plaintiff's motion for summary judgment is granted. No later than 7 days from the date of this order, the parties shall file a proposed judgment consistent with this order and include language that enforcement of the judgment is stayed for 30 days to facilitate an appeal. Powerful language there from Judge William Hayes right there, right now. Now, I should also give you some great quotes. The Second Amendment Foundation and the Firearms Policy Coalition were both involved with this case. I'll just give you a couple quotes from Alan Gottlieb of the Second Amendment Foundation. This is what he said in light of this ruling. This is a win for gun rights and California gun owners. There is no historical justification for limiting law-abiding citizens to a single handgun or rifle purchase during a 1 month period, and Judge Hayes' ruling clearly points that out. Great quote there from Alan Gottlieb, and I'm going to leave you with this, a great quote also from the decision from Judge Hayes himself. Here's what he had to say as he summed up and pointed out why California loses this case under the Second Amendment. Judge Hayes wrote, "Defendants have not met their burden of producing a well-established and represented historical analog law. The court therefore concludes that the plaintiffs are entitled to summary judgment as to the constitutionality of the one gun a month law under the Second Amendment." Powerful language, a big win. Now let's see what happens with the Ninth Circuit. Obviously, we never know what happens with the Ninth Circuit. Usually they're terrible. Sometimes they surprise us. Let's hope we're surprised and this ruling is upheld pending the process of appeals. But one just doesn't know. I will keep you informed as this case is developed and moves forward. But again, congratulations to the Firearms Policy Coalition, the Second Amendment Foundation, and the other plaintiffs in this case. Big win for the Second Amendment, big win for rights in California. Let's keep it going. All right, folks. Well, again, we're having some issues with people getting unsubscribed, and subscriber growth is really slow. I don't know why, but please subscribe and resubscribe to my channel, 4 Boxes Diner. I'd appreciate it. Don't forget to follow me on X at 4 Boxes Diner, and we will see you again soon here. Yes, indeed, at the 4 Boxes Diner.
Orders up. Table 2A.